And now, let the panels begin. By the way, there are seats in front for those of you who are standing in the back, so don't be shy. Feel free to come down and take one. Our first panel is Best Practices in Alternative Programs, and I'll ask our panel to take their seats. Okay. All right, so I'm going to introduce our moderator, who will then introduce our panel. Our moderator, Raul Ayala, is the Deputy Federal Public Defender and the Collaborative Court Supervising Attorney in Los Angeles, California. In that capacity, he is the lead Deputy Public Defender for each of the district's courts for its Conviction and Sentence Alternatives, or CASA program, as well as a member of the Substance Abuse Treatment and Reentry, or STAR program, two of the oldest and leading pretrial alternative to incarceration programs in the country. He's been involved with these programs for the last 12 years. He's also the chair of the ABA Criminal Justice Section's Alternatives to Incarceration and Diversion Committee. And I turn it over to Raul.
Thank you. So good morning. Buenos dias. Okay. So we have an hour, and I assure you we'll have 10 minutes for questions and answers. So write down your questions as we go along. We definitely want to have it an opportunity to answer your questions or hear your thoughts. But before I introduce this very distinguished panel, I'd like to first thank, of course, the Olive Institute, the Center for Justice and Human Dignity, for your attendance and interest, and of course, Dr. Morland Capulla, who set a very high standard, right? So no pressure, we'll follow that. So I am indeed very honored to be moderator for this panel. It's something near and dear to my heart. That's what I've been doing for the last 12 years. I've got the best job in the office. Please don't tell my defender. So with me, of course, is Chief Judge Michael Urbanski, who is the Chief Judge for the Western District of Virginia. He's been doing these programs for the better part of 15, 20 years, first as an MJ, now as a district judge. We have with us District Judge Andre Birotte, who is a former U.S. Attorney for the Central District of California and currently a CASA judge for us in our district, been with us since the beginning of the programs. We have with us Marie Kerrin, who's a program manager for LEAD out in New Orleans, former social worker with the Public Defender's Office there in New Orleans. And last but not least, the GWU's very own Professor Kate Weisburd, who's written a lot and done research on some of the issues affecting alternatives. So thank you all for joining us. So, thank you. So I'm going to make some very brief comments, and of course, if you believe that, I've got a bridge to sell you. Those that know me, right? You know, I'm really resisting the urge. You put a trial attorney with a podium and a microphone and a captive audience. Boy, you know, you'll get tired of me real quick. But I'm going to have some very brief introductions. And we're not going to talk about what's been research. I'll tell you what we're not going to talk about, and that is what's the research shown, what are the best practices, you know. Very distinguished groups like All Rise, formerly the National Association of Drug Court Professionals, puts out, you know, their adult drug court best practice standards, right? You know, and if you haven't seen those, you got to read them, right? If you're going to be involved in this kind of work, there are a lot of standards, right? And I'm just going to rattle off the topics that they say we should consider. Of course, target population, equity and inclusion, roles and responsibility of the judge, incentives, sanctions, and therapeutic adjustments, substance use disorder treatment, complementary treatment and social services, drug and alcohol testing, multidisciplinary team, census and caseload, and of course monitoring and evaluation That's all, right? So, from beginning to end, we have to really give some thought, and there's been research. There's a lot of great organizations, including SAMHSA, of course. The Council of State Governments Justice Center has a whole module on how to put together a mental health program, for example. NAPSA, the National Association of Pretrial Services Agencies, also has some standards. The National Association of Forensic Social Workers has standards, so there's a lot. The Hazelton Betty Ford Foundation has a lot of documents and reports that we can learn from on how to do our job as best we can, right? Because where are we? We're in of course, last but not least, and Judge Donald knows this, the ABA, we just completed a task force that I was fortunate enough to chair to put together some diversion standards that got passed by the House of Delegates last summer. We're finishing off the commentary, so it'll be in printed form in the next couple of months. You can go straight to the black letter standards by going to the website of the ABA Criminal Justice Standards. So a lot of people have given a lot of thought is what's the best practice to handle these kind of programs? We're not going to talk about that. We're going to talk more about the practical best practice standards of implementing alternatives to incarceration programs, primarily in the federal court, not exclusively, but I'm a federal defender. Shout out to all my federal defender peeps out there. We have 2 federal judges, and we have some other practitioners, or former practitioners that are involved in this, state and also giving some thought to the federal. So, we're gonna talk about that. And last, I'll just say, as we know, this is the intersection of criminal law and practice, or procedure, and behavioral health science. I don't know about you, I've got trained in only one of those areas, right? And of course, some of my folks may say, Mr. Ayala, I don't think you've been trained in either. Because I am, and you know who's out there that would say something like that. So in any event, that's kind of the backdrop. We're going to talk more about the practical and perhaps some policy discussions. Think, how do we institutionalize these programs? Right? Think about that for a second. In the state courts, we have statutes, we have rules of court, we have funding from the federal government to do these programs in the state system. We don't have anything in the federal system but for the prosecutorial discretion that different districts afford. Okay, that's a good start, but it's not where we should stay. Right? We need to figure out how do we institutionalize, and hats off to the Sentencing Commission who's asking that precise question in the last 2 amendment cycles. How do we address alternatives to incarceration in our guidelines? So, Judge Birotte, I'm going to start with you. As you know, you were U.S. Attorney before you became appointed to the bench. So why and how did you decide to engage in collaborative courts as the U.S. Attorney?
Well, can you all hear me? I guess as much as I'd like to take credit for coming up with some new and novel idea, that would be a misstatement. I started out as a public defender, and many jurisdictions locally have sort of diversion-type programs. And when I was a county public defender in Los Angeles, they had a program where basically low-level offenders, no records, if you didn't commit any crime, case got dismissed. Nothing more formal than that. And so when I started as an AUSA, I wondered if there was a similar program. There was not. I'm a line soldier. I do what I'm told, and so I just left it at that. When I came back the second time, Judge Wright had started a program called STAR, which was looking at things on the other end, the reentry programs. But there wasn't something on the front end. And Judge Wright and I had a conversation, and I joke about this all the time, about the fact that we were talking about different ideas, and I was like, could I do that? And I was the boss, so I guess I could. And so that's how it started, and we just started working with Public Defender's Office, probation, pretrial, and that's how it got started. But to your point, which I think is something that we all need to think about, and I'm preaching to the choir here in many respects, is how do we institutionalize it? How do we make it so it's not just linked to the individuals? In my case, we were lucky. The stars sort of aligned. The chief judge was on board. The public defender and I had known each other when we were baby lawyers. So the stars all aligned. Some of my colleagues didn't have that experience during that time when I was U.S. Attorney trying to implement those programs. And I think the challenge and the hope, I think, for all of us is to try to walk away with different ideas. I've heard some comments from good friends of mine that are judges that have started foundations in their district to help fund these programs. try to just keep it institutionalized in the fabric of the district. Our website, our court website, talks about the CASA program, with the hope that whoever comes in, because as you point out, the reality of it is, if the prosecutor doesn't want to play ball, that can be the end of the program. And so the hope is that you create enough momentum that no one will even think about doing that. But ideally, look, with the Sentencing Commission looking at these issues, the momentum of programs like this, we will maybe get something, whether it's congressionally or statutorily, to sort of set things in motion here throughout all courts in the country, federal courts.
Thank you, Judge. Judge Urbanski, you want to talk a little bit about that, please?
I got started in this when I was magistrate judge, and I got started when I was seeing a lot of misdemeanor prosecutions for veterans, folks who really didn't need to be in criminal court. They needed to be getting mental health and substance abuse treatment. And so I went to our local VA hospital and I said, what can we do to help us do this? And they said, well, sorry, the folks you're seeing, there's nothing we can do for them. So, thanks, but no thanks. And then an administration or two later, I was dealing with a couple of young men who were charged with either standalone crimes or they were on supervision, and they had some supervised release violations, who had come over from some of the Iraqi or the Afghan war. And I remember one young man in particular his job was to, he said, process the casualties. His job was to take the folks who had died, dress them in their uniforms, put them on the airplanes back to Dover Air Force Base. And he was a mess. He was so traumatized. He was treating himself with alcohol and substances. And so I went back to the VA and I said, we've got to do better. And at that point, the VA had got some funding. They were interested in this, and they set up a program with us. We were either the second or third veterans treatment court in the country, and I didn't create anything. I followed really a pioneer in this field, Paul Warner, was a magistrate judge in the District of Utah. I talked to him. I copied everything he did, and we implemented it in the Western District of Virginia. And it's a small program, and it's not only just on supervised release cases or folks with misdemeanors, but we're also using it with folks who are veterans on the pretrial, the diversion end, and that's helped some too. And 20 years ago, I came on the bench, and when we started this, one of the real problems with us as a system was the lack of mental health and substance abuse resources that were out there. I mean, if you had insurance, you could get treatment, right? But there was no insurance for most of the folks that we saw. It was only with Medicaid expansion that we have many more resources available for folks. And so that program has been very helpful. I went to the district court bench and really grew tired of seeing 18, 19, 20-year-old, largely young men who were facing 10, mandatory minimum 10, sometimes 20-year sentences for drug distribution. To follow up on something Judge Donald said, when you talk about the front end and the back end, we're dealing with the back end, but on the front end, the one common denominator that I saw with folks who are involved in these crimes were they didn't finish high school. They just didn't finish high school. It wasn't race, it wasn't gender, it wasn't national origin, it was they didn't finish high school. So I thought that was interesting. And so we started a drug treatment court. I started it when I was chief judge, and you've got to have the buy-in, as Judge Birotte said, from the U.S. Attorney, And it's a collaborative process, U.S. Attorney, probation, federal defender, and then a real team of community resources. Because if you don't have the community buy-in, they're the real heroes in our program. We have a guy who works with our program. He volunteers 4 hours a month. He's the chief of psychiatry for our local hospital, and he was the former, Dr. Bob Tressman, former head of the Connecticut medical director for the Connecticut Bureau of Prisons. And he sits in and provides us with some sort of clinical wisdom. So, following up what Dr. Moreland Capuya said, sentencing is the hardest thing that we do as judges. Sentencing is the hardest thing that probation officers do, that prosecutors do, that defenders do. You talk about secondary trauma. It's there in sentencing. And one of the things these programs do is they give us a little ray of hope. It ends a little bit of the isolation. It ends a little bit of the loneliness. You work together as a collaborative team as opposed to somebody who's just sitting up on the bench. And it is the best work I do. It is the most uplifting, the most rewarding. It helps with my soul. There's a young man I sentenced several years ago who's now in our program because he had a supervised release violation. And he told me that when I sentenced him, I was thinner. He says, now I'm fat. Really neat young man.
That's not an aggravating factor.
Yeah, no. He, and he's going to graduate from our drug treatment program. He has had his fits and starts. He has been, we've put him in custody a couple times, and he's had his fits and starts, but he has gotten with the program now. And he has, he graduates next month, and we've planned a little, he and I are going to go running together. He says, I need that. That for me, to Dr. Moreland Capuya's comments, that helps me end the isolation. It helps me end the loneliness. It is teamwork. It is something that is incredibly meaningful. And it is, like I said, it is the, I think Dr. Moreland Capuya said, it's a place for me, to quote her, a place where joy and meaning are possible. But institutionally, if I didn't start this, if I didn't get the buy-in from the U.S. Attorney and the defender and probation, it wouldn't happen. There's nothing in the code. There's nothing in the guidelines. There's nothing in the guide to judiciary policy. There's nothing. We're doing it on our own. And I didn't make this up. I followed the bridge program out of Charleston, South Carolina, Judge Brucey Hendricks. And we just did it. And I do worry that maybe the U.S. Attorney one day will say no, right? But so we need some institutional backup for this, because right now we are doing it. There's three district judges in our district that work together in this program, and we're sort of doing it on our own. But we do, and the funding is just coming out of probation funds. There's more supervision, there's more involvement. So we need some institutionalization to do it. So sorry for talking. Sorry for taking so long.
No, it's good. Thank you, Judge. So we talked a lot, of course, about substance use disorders in these programs, but there is the mental health component. And so, Marie, tell us a little bit about your work in mental health and how your work with LEAD and individuals on the street looks like.
Sure. So LEAD stands apart a little bit from some of the traditional court programs that we're talking about today. We don't require any abstinence. We don't mandate behavior. Once you're in our case management program, we follow a harm reduction framework. For me and my background, oh, is it? Hello, can you hear me? Okay, so just to back up. So, well, let me, to explain LEAD. So law enforcement assisted diversion. We work with officers and other criminal legal system stakeholders to provide an alternative to arrest for low-level nonviolent offenses when a person just needs help. So we get folks even before they've entered the court system sometimes, and then other times we do have to work with folks who are already in the court system. What we step in to provide, our case management model stands out in the landscape of, well, what we have available in New Orleans, but I think in many places too. We are long-term, intensive, not tied to any Medicaid funding, which means we can support people on their own terms as long as they need us. What I was saying before, I didn't realize the microphone wasn't on. We don't require certain benchmarks of success. We don't mandate behavior, require abstinence. We are with people for as long as they need us with unconditional positive regard. This helps to support folks who maybe failed out of other traditional treatment programs, who weren't able to complete a certain timeline in their recovery. So that, and then to me, as my background as a social worker and what I saw when I was at the public defender's office, this is a solution to what I was experiencing in my direct service work so I felt so limited by the fact that the work that I could do, the therapeutic work I could do with clients was tied to a legal case, and I would feel this division between seeing clients who are incarcerated and seeing clients in the community. But what we're doing now is creating an alternative system of care within the community. All these systems collaborating, as you all are describing, everyone is collaborating. The prosecutor's office, the public defender's office, municipal offices, community and municipal legal system stakeholders come together to collaborate for LEAD.
I imagine that those first steps weren't that easy, right, to get collaboration. So what were some of the key components that make that happen?
What I have found, so LEAD kicked off in New Orleans at the tail end of 2017, experienced a funding lapse during COVID, and was non-operational for approximately 2 years, just under 2 years. So I came on board in 2021, and we were starting essentially from scratch because, speaking of institutionalizing these programs, I had to start over again building the key relationships that were the driving force to make these things happen. So I think that really, I think about this in my personal life, and then also reflecting on Dr. Kapuya's presentation, and just, it is the relationships one-on-one with others, and then for me with clients, but then also at this more macro level with other policy level stakeholders. You find the folks that you have some buy-in with, and then you build that momentum then to make it into policy, and we're seeking then policy change within each consecutive department. Sure.
So people have a misconception about people with mental health, right? That they're scary, they're dangerous. And so what did you have to show those stakeholders, in particular maybe judges and others, that isn't the case, right? How do you manage individuals that suffer from mental health in an effective way so that it's not so stigmatized?
That's interesting. I suppose I think just humanizing, telling stories, understanding and knowing what is going on for individuals, and then being able to communicate that. I certainly did that a lot when I was a social worker in the public defender's office with some of the pretrial mitigation that I would do. It's just, you get to know people, you get to know their stories, and helping humanize and build those connections.
Thank you. So I'm going to switch gears a little bit here. I'm going to turn my attention to the professor. You know, there's no doubt that you're an advocate for reducing incarceration and alternative programs, but you've written you've written extensively on the use of electronic monitoring, for example. So tell us a little bit about what are some of the primary issues that you see in the use of that alternatives in these alternative settings.
Yeah, so it's really nice to see everyone, a lot of familiar faces in the audience. And I will say, prior to joining academia, I represented young people in juvenile court in California, and very much appreciated the way, for better or for worse, that ankle monitoring often allowed the young people I was representing to get out of custody. But I also saw firsthand how the restrictions and realities of ankle monitoring led to social isolation, speaking of the session this morning, stigmatization, and really undermined rehabilitation. I'll never forget a young man I represented who was released on an ankle monitor, and he had not been going to school, and the judge really understandably wanted him to go to school. Going to school was actually a condition of his probation. And we finally got in place, with the help of social workers, an individualized education plan so he could be supported in school. And he finally went to school, and on the first day he finally went to school, his ankle monitor started beeping in the middle of his class. And the teacher stopped class and said, "What is that noise? What are you wearing? Why are you wearing that?" And not surprisingly, he then stopped going to school. And so I just offer that as an example of a sort of unintended consequence of electronic ankle monitoring. I should say, too, that in my research, and I've gathered and analyzed the rules governing electronic ankle monitoring, what we see is that the rules are often extremely cumbersome. They're extremely extensive, they're often unnecessarily restrictive, and can result in people making it really challenging for people to live their lives. So for example, just the social isolation of being stuck at home can be really damaging. Rules that require advance permission to leave the house, the onerous charging requirements, strict rules governing when and where people can go places makes it really hard to say, go to a job interview, or maintain a job, or take care of family members. These are all very difficult on a monitor. The hardware and the software is also far from perfect. The GAO just released a report on the use of electronic ankle monitoring in the federal system pre-trial, and the majority of pre-trial officers all reported challenges with the technology. The other thing, too, is that there's just not a lot of research. I mean, like my fellow panelists, there's a little bit of a gray zone when it comes to the use of electronic monitoring, both as a legal matter and in terms of just, is it a good policy? Is it actually working? And there's not a ton of evidence out there that electronic ankle monitoring, as compared to a less restrictive forms of support, so for example, text message reminders or assistance with transportation to court or to treatment programs, there isn't a ton to suggest that ankle monitoring is somehow more effective than those less restrictive options. And the last thing I'll say, too, is that I don't think we have a great sense of who the right population is who should be on an ankle monitor. Ideally, it should be being used on people who would literally otherwise remain in custody, but identifying who that group of people is actually really challenging, but also really important, because if we don't do that, it will just result in net widening and people coming back into the system, not for new criminal allegations, but for violations of these extensive rules. And I have some ideas of what we can do, but I'll save that.
Well, we're going to get back to you, but you know, there's this recent book called Mass Supervision by, is the author out here? But it's you know, the very first chapter, and I want you to address this, please. It's called The Death of Rehabilitation, right? So we think about the criminal justice system that is supposed to have these two components that we hear about, read about, you know, punishment. We all get that, and they get plenty of that. But what's happened about rehabilitation? So, you know, talked about what's led up to this mass supervision and electronic monitoring. What are your thoughts on that, Professor?
Well, what's so interesting is now, and I think that book is really great in revealing this. I'll just be really brief, but what we now know is that the research overwhelmingly tells us that lighter touch supervision and fewer rules leads to better outcomes. And I think that book does a beautiful job laying out the case for it, so I won't repeat what's in the book, but I strongly recommend it. And I think that ankle monitoring, I mean, one of the concerns is that when you just pile on rules and restrictions and rules and restrictions and rules and restrictions, it's just setting people up to fail. And it really does undermine the ability of people to survive and thrive outside of custody.
Thank you.
Doesn't that go straight to what Chris Poulos was talking about? And that is the everyone was telling him no, as opposed to what he can do. You know, this issue of rehabilitation, you know, when you look at the 3553A factors under Title 18, when we're considering the factors that we're supposed to use to impose a sentence that is sufficient but not greater than necessary, you got to go down a ways in those factors before you get to rehabilitation. And one of the things that we need to focus on, talking about going forward, is more rehabilitation at the Bureau of Prisons. In fact, I would suggest that, you know, right now, if we've got somebody who needs a psych evaluation, mental health evaluation, it takes a long time to get that. And that person is just sitting and sitting and sitting and waiting. We need more resources devoted to folks in the Bureau of Prisons and those who are out for mental health treatment. And I would argue some of these places ought to be standalone as opposed to attached to a Bureau of Prisons facility. In a perfect world, I would have this huge substance abuse treatment facility that, so many of the people that I sentence are victims of addiction, right? And they're involved in these drug conspiracies that I'm not talking about violent offenders. I put that in a different category. But I'm talking about folks who are selling drugs to serve their addiction. And there's so many of those. And those folks really don't need to go into your traditional Bureau of Prisons facility. They need to go into a standalone facility that doesn't exist in my perfect world where they can go and get what they need, and that is treatment, where they can go and get what they need, that is rehabilitation. And we spend a lot of times talking about, the factors, the goals of punishment factors involving protecting society, the need for the sentence imposed to reflect the seriousness of the offense, provide just punishment, all those other things under 3553A. But that rehabilitation factor, we need to spend more reason. I'm not over there on Capitol Hill, okay? But we need, in order, look, I've been doing this 20 years, okay? And a lot of you have been doing it a long time. Are we making any progress, okay? And so that's the question we all have to ask ourselves there every day. Are we making any progress? Are things any better? And if not, maybe we should do something differently. And I would argue for greater emphasis on certainly mental health and substance abuse rehabilitation. And I know the Bureau of Prisons does what it can with the funding that it has, but I would think it needs to be a national priority. That's my 2 cents worth.
Thank you. In terms of evaluation, there'll be a panel later led by Christine Dozier, who used to be the chief probation officer or pretrial officer in New Jersey. She's done some research, so that's the other component, of course, is to evaluate our work. Right? But you can't evaluate if you don't set it up properly, and I think that's part of our issue. Judge Birotte, I'm going to return back to you. Now that you've been doing this program from the bench for the last, 8, almost 10 years, what do you think have been some of the highlights that really have worked, and what are some of the challenges that we've faced?
Look, the highlights are things that we've talked about, just seeing people go, seeing a community work on healing, and seeing folks that, whether they've never had a bank account, know nothing about basic nutrition, learning about their trauma and how to deal with it, and doing it in a community. It was interesting hearing Dr. Moreland Kapur talk about it. Raul, when we meet every Wednesday, that's tough work. It's tough work, and it's draining, but it's important. We're in the dark with a lot of these folks and trying to get them to the light. And so seeing that each and every time is ultimately fulfilling. Look, again, I keep saying we're preaching to the choir here. If I rule the world, we would be having this in Congress or in front of a Senate to show them what we're talking about, have them come to a CASA graduation to see people who are struggling and have made it to the light, to basically let them know this is where the money should be spent versus the 3 hots and a cot at a federal prison. And so those are definitely the highs. The challenges, I think, are somewhat related. It's just helping those folks get through the light and going through the issues that they face. Every week we hear story after story and helping them navigate through the trauma. And I will tell you, I'm speaking amongst friends here, there are many times I just feel wholly inadequate to sort of deal with the issues that are confronted. And we've got a great team of probation officers, mental health counselors, but here I am, I'm like, this is, hard stuff. And thank God for brown liquor on Friday nights. No, I'm sorry.
And is that all, Judge?
No, right. No, I'm just serious. But that's the hard thing. And again, I keep harping on this. For me, the big challenge that I wish I had an answer to is just trying to make sure that this gets institutionalized. In an ideal world, if it was the AG, and even that still puts the ball in the prosecutor's court. if an AG issued an edict, encouraging each and every U.S. attorney to implement diversionary type programs, or if it came from higher, because my worry, my big fear, and I've been fortunate enough, I'm not old enough yet that the U.S. attorneys that have succeeded me, I knew them. So like, I could have a conversation with them like, hey, congratulations, hook your boy up, don't mess this program up, But there may be, at some point, I want it 10, 15, 20 years from now where it's not going to be an issue, and that it's going to be part of the fabric of every district. Because in my view, every district should make an effort to do some sort of diversionary program, because I am convinced that the money spent on the 3 hots in a cot could be far better utilized in programs like this with far better results.
Let me give the statistic, Judge, before you say your comment. So there are 94 judicial districts. I'm sorry. There's 94 judicial districts in the United States, right? By my count, there's about 647 plea and post-convict, pre-trial and post-conviction. So 62 districts out of those 94 have something, Judge. That's like 2/3. Now, if that isn't crying out loud that people are interested in doing this, that the court is interested in doing this, probation is doing it, we're, of course, in from the beginning. And yes, we've had those edicts from the Department of Justice, but they've been recommendations, right? You can't force a U.S. attorney from X district to do this, and that's got to change, in my humble opinion. Judge?
To echo what my colleague, Judge Birotte said, we're in an age every year, as Chief Judge, I hear about, okay, we're facing 18% budget cuts. We're facing 12% budget cuts. And and who knows what happens in 3 weeks, right? But with what goes on, we don't have any statutory authorization there's no line item that says, okay, this is going for your drug treatment court, right? Probation uses that and probation does the lion's share of this work. They're the ones who are in there every day meeting with these people. But I worry about, in an era of budget cuts without institutionalization, whether these programs could be just swept aside. I also worry about, I'm not going to worry about that when my chief judge term ends, because my colleague who's taken over for me is a huge proponent of this. But if we didn't have a chief judge who was in favor of this, that program goes away, right? If we didn't have a U.S. attorney and a defender who were committed to it, that program goes away. Judge Birotte talked about making it to the light, getting these folks to make it to the light. And I just want to share this. It's something that I've learned over the past 4 or 5 years, and that is all the people who come into our drug treatment court program or our veterans treatment court program, they come in with the notion that, oh, all right, I'm going to snow this judge, all right? There is, I'm just going to do what I can to get by. I'm going to try to use, and hopefully they won't test me on this day or that day. I had one guy who had an alcohol problem who said, no, I wasn't drinking. It was the beef bourguignon that I was putting the wine in, right?
I was nowhere near that participant.
all of these folks, when they first come in, because they have been treated in the criminal justice system, and they're totally skeptical of us. We're the enemy, right? We're not out there to help them. We're the ones who send them out that other door in the back of the courtroom. They don't. But over time, this program's a year or 18 months, and the ones that are successful are the ones who realize that after a few failures and after a few fits and starts, that we really do want to help them succeed long term. That's when they see the light. That's when they get the buy-in. And those are the folks who are successful. And it actually takes a couple of folks in a drug treatment court program to use. And they get sanctioned. We have graduated sanctions. Sometimes I had one person who I just put her in jail for the afternoon till 5 o'clock. And boy, she was really great after that. She'd never been in custody before. But it's really interesting. It's not only skepticism amongst us, right? Probation, judges, prosecutors. It's skepticism among the folks who are in our program, because they don't trust us. You know, they certainly don't trust me. They don't trust probation, because everybody's out to get them, right? They don't trust the prosecutors. But once they realize that this is different, that this is fundamentally different, it's a collective process to help them, that's when they see the light, and that's when we have our success. And we've had our share of failures, right? It's not all one size fits all in this. There's all kinds of different ways to solve this problem. But they have to buy in too, and it's trust. They have to trust us as well as we have to trust in them a little bit. Sorry.
That's true. So, Ms. Kerrin, what does that look like in the mental health arena, right? How do you get success when you're not, enforcing certain rules that we do in court, for example? How do you get success?
Right. Well, that was reflecting on the difference of how LEAD operates, which because we're long-term and outside of the mandated, you have 18 months to complete, and this is what completion looks like, and these are what the benchmarks look like. It means that we can essentially support the folks who wouldn't be succeeding in that setting. And I do know that for some, especially with people who have serious psychiatric conditions, sometimes there is that black robe effect, and it is really effective to come into a room where you've got to be accountable, but just, speak to and have folks paying attention to your recovery. That definitely works. And also to supplement it, there is what we offer, which is we're there for you when you do relapse, or when you're when you're experiencing an episode of psychosis and you're not taking your meds. We're going to be alongside of you and help you get to a place where you can make healthier choices on your own terms, because that's the kind of recovery that sticks for a lifetime, is when it comes from the inside. So I also think about how can court systems and how can systems that have more mandated models have that sort of approach of just accepting failure in a different way. And so that's the LEAD approach, and I think about that in terms of substance use, but yeah, psychiatric conditions too. I mean, they're very different, of course. Relapse looks different when you're off your medication versus in an episode when you're using substances again, but same sort of empathetic, just how can I help you? Let me sit down beside you and just, okay, you're not ready to go to treatment? Do you want a sandwich? Great, let's go. You want some cigarettes? You want me to bring you cigarettes to treatment? Great. Do you need to go to treatment again because it didn't work out that time? That's okay, I'm there for that. And we have people who started in LEAD in 2017 who are still with us. So think about the end of 2017, we had our program lapse, and now it's 2023. There's this one person in particular he was one of the first participants in the LEAD program in New Orleans. He was identified by the officers in this one police district as the highest utilizer. He had, I think it was 300 field interview encounters with police in the year before LEAD. He had been arrested 23 times in that first year before. And in fact, over the 3 years before he enrolled in LEAD, he had spent 1 full year in jail, cycling in and out every couple days on low-level offenses. In the year following LEAD, he was arrested twice, and then since that point, he hasn't been arrested again. Now, he calls his case manager every single day to this point. She is constantly dealing with crises, but I think that's the point then, is now we've got a community-based, long-term system of care to support him so that the courts and jails don't have to be stepping in to provide that care.
Thank you. Professor, to some extent, electronic monitoring is to serve some type of behavioral change, right? Like we often think, okay, I'm gonna send you to jail to change your behavior so you can learn your lesson, so to speak. What does your research show? I know you mentioned it earlier. Are we missing the mark? Are we exacerbating the problem? What are your views on that now that you've studied it for a while?
Yeah, so I think the research is pretty clear that monitoring is really challenging. The rules of monitoring are really challenging for people who are suffering from mental illness and for people who are struggling with remaining housed. I think part of the problem is that the rules of monitoring are usually an on-off switch. It's sort of like they're never modified for the individual person. And frankly, the way monitoring operates, it can actually be sort of tailored to the individual needs of the person who's on the monitor. So I think there's a few ways in which we can, some important questions to consider in thinking about how electronic ankle monitoring, or for that matter, SmartLink, the application that's now being used, I know, in a lot of federal districts, how we can think about using that technology in ways that are perhaps more effective. So the first is just, is it being used on the right people? And kind of identifying, well, what is the actual goal of putting someone on an ankle monitor? If it's rehabilitation, is there something less intrusive that can accomplish the same goal? Because again, the research is pretty clear that something as intensive as a monitor and all the rules that go along with a monitor generally sets people up to fail, and that a lighter touch is much better. For example, monitoring could be used to just enforce curfew, or it could be used on a certain type of case, or a certain type of person who really could benefit from the sort of rigidness of it. Or maybe sort of pro-social job-related activities are just presumptively allowed, and so people aren't required to get permission to do those sorts of activities. And sort of rejecting this one-size-fits-all approach to monitoring. I also think it's really important to consider the data that's at issue. This is highly sensitive geolocation data that, per the Supreme Court, can't be accessed without a warrant. This is really a Fourth Amendment gray area in terms of just placing someone on a monitor is a Fourth Amendment search, as is law enforcement's use of GPS data is also is also a Fourth Amendment search. I think there's also a question of custody credit. In some jurisdictions, at least in some states, have found that when someone is on house arrest and subject to an ankle monitor, that they get custody credit. And also, some exciting areas of reform are limiting how often someone can be incarcerated based on a violation of electronic ankle monitoring. And if people are interested, I can definitely point you in the direction of some states that are doing, I think, exciting work in this area. And then, very relevant to the client that I described earlier, just banning the audio features of these monitors, I think, is really, really, really important.
But
You mentioned SmartLink, and just in our district, it seemed like the electronic monitoring, they're like Motorola brick phones, like they're like humongous. And I just kept thinking, like, wait, Apple's got these AirTags that are like this big. Like, is there not an equivalent in the federal for monitoring right now?
Yeah, and I know there's people in the audience who probably know more about this than I do, but the SmartLink is a cell phone application that's meant to replace the clunky ankle monitor, and the ankle monitors are, I think, increasingly getting smaller for exact reasons you suggest. I think it's a little bit of a red herring because it solves some problems but not others. So perhaps it solves the physical stigmatizing aspect of the monitor, or perhaps it solves the like audio feature problems, but it doesn't address many of the other issues, which is the surveillance and the rules and the restrictions.
you know, it's interesting that you're, Professor, that you're talking about these issues, but usually when someone leaves my courtroom on an ankle monitor, they've won. You know, I mean, they're happy, right? They're not going into custody. They're going on the ankle monitor, and folks usually, generally, really like that. Does your research suggest any sort of change in their attitude toward when they first get it, and then if they're on it for long periods of time?
And it's a great question. To be clear, I mean, I was in the position of being a defense lawyer who represented people who were similarly very grateful to get out of custody on an ankle monitor. I think part of the problem is that it's a little bit of a false binary, because I think that, of course, anyone would want to get out of custody on a monitor. But the third alternative is to get out just with support, maybe be in a problem-solving court without the monitor. And I think that's a little bit of the challenge with the monitors. It's like the shiny new car problem, which is, of course, it's appealing, but it almost obscures the idea that there's other options out there other than the monitor. And I do think, I'm really grateful you raised the point about the amount of time someone spends on a monitor. I do think that initially it is so appealing, but over time, it gets increasingly harder, which is, again, in some states, some of the reform that I've seen that's been quite successful is limiting the amount of time someone can be on a monitor to sort of a presumptive 30-day maximum, and then there has to be a hearing in order to have them remain on the monitor, just sort of recognizing that it is very restrictive.
What states are doing that? Can you think of any off the top of your head?
Yeah, so California just passed a law, at least in the juvenile system, where there's a presumption, where every 30 days, someone has to come back to court. And I can give you more information on that.
Thanks.
And Illinois as well.
Thank you all. So we're right around the 10-minute mark, so I promised that we'd have time for questions and answers. We have a question back there. We'll get you a mic. And while we're waiting to get you a mic, there should be a handout that you can get from the app over here in the, where you can get some of these resources, including some of Professor Weisburg's articles. Yes, sir.
Thanks. Yeah, just to follow up on that, oddly enough, I was someone who was on a monitor for 2 years, and I just wanted to say that, yeah, of course, I was very grateful that I was out on a monitor. That did not make the monitor a good thing. In my experience, it was quite oppressive, often painful, and extremely expensive. It's been 10 years, and I'm still paying the monitor off, to be honest with you. So, when we think about these things as alternatives to incarceration, we have to also, I think, be thoughtful about the larger impacts of those actual things. Yes, they might be better than incarceration. I certainly would much rather have been out than much rather have the monitor than have been in prison still. But it is not a panacea in the way that you were saying, like we were excited about being on the monitor in my experience.
Thank you. Another question? Thank you.
Hi, I just wanted to share and back up Judge Birotte's suggestion about how to institutionalize some of these programs in terms of funding. Is that on the front end and the back end, you're reliant on pretrial and probation's budgets. So in Chicago, I run our reentry program, so the back end program, and we have started a 501c3 foundation to start funding for all of our programs, so front end, back end, and Veterans Court. And what that does is it makes the courts more independent. You are then not stuck, worried about somebody else's budget, and then can also set the priorities for your programs financially. And we have retired judges that are then able to go out and fundraise for us and tap into some of these federal grants that otherwise we're not eligible to apply for. But the foundation can do that because it's separate. So that's one thing to consider. I'm Sarah Ellis, a district court judge from Chicago, so feel free to email me. I'm happy to send you what we did to set these foundations up.
Great, thank you.
And thank you, Sarah, for raising that, because I didn't want to out you unless I had your permission, so thank you.
Out me away.
Another question? Over here. Yes.
Hi.
Hi.
I'm sure many of us look forward to the day when sessions like this are simply called best practices, and they're not the alternative. They're the norm, the predominant response. I want to go back to the beginning of time, 1L year of law school. Knowing what you all know now, do you have thoughts about how legal education should change?
That's a good one. I can't think that far back, but Professor?
Oh, I have lots of ideas of how legal education can change. I do think that part of it is just, and what I try to, the way I teach criminal law and criminal procedure is really making students understand that these aren't just words on a page, but that they exist, that these are real lives, real people. And so I often, I'll always have prosecutors, defense lawyers, judges come and speak to my students. I assign podcasts, sort of direct experience of people directly impacted by the criminal legal system. So people charged with crimes, victims, family members, trying to get those voices into the classroom so that the students understand just how high the stakes are, and that this isn't just an academic abstract exercise, but that it really matters for real people.
So the question is, do we think that alternatives apply only to nonviolent offenders and not violent offenders? That's a good question, a lot of debate. Anybody want to tackle that?
I mean, the short answer, I do think it works. I mean, it's giving an because whether they're violent or nonviolent offenders, more often than not, they have some trauma or some circumstance that brought them to the criminal justice arena. And my view is that anything that can help address that and hopefully provide them an opportunity to change the pathway of their lives is worth it. I mean, Raul hears this all the time. Every CASA program participant, I tell him, have you ever seen the movie Willy Wonka? And they all, with the exception of one person who grew up in Armenia, he'd never seen it, but they all say yes. They say, you just got the golden ticket. And you have a chance, if you work hard, there are going to be some trials and tribulations, but you have a chance to change the pathway of your life. So whether it's violent or nonviolent, I think that it works. It has the potential to work.
So I would add to that that the research by the experts say, the high-risk, high-need individuals gives us the best results when we give them the alternatives, right? And so definitely somebody who's got some violence in the background, likely high-risk, high-need. And we get more bang for our buck by providing services for them. Right? Right, that's true.
But I think, that's interesting. Hopefully, look, we're the baby steps of this, right? I mean, our program CASA started 10 years ago, right? And you're right. When we first started, look, I was like, no violent offenders. I don't want that problem, blah, 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 blah. But over time, research has shown, and we're slowly allowing that, giving it more opportunity. The greater the success rate, the studies are supporting it. So hopefully, over time, it will be opened more and more to those individuals as well.
And one place to do that, at least for starters, is in a reentry court program where folks are coming out of the Bureau of Prisons or out of the state correctional institutions, and it isn't one size fit. It's all kinds of offenders in there, and using that program to work with them to help them get their driver's license, to pay off their child support, to get them a job, to do all those things that they need, and then reduce their period of supervision at the end. For me, that's a place where I think all kinds of offenders have a place is in that reentry forum.
I think we have time for one more question. Yes, sir. Want to use the mic, please? Thank you.
So, long story short, I was sentenced to 40 years in federal prison. I spent 20 years of my life in there. I wrote the Conrado Cantu case from my prison cell in FMC Lexington. That was the first compassionate release motion to be granted. Eventually, Judge Gleason would take over my case after I filed pro se. We won, I got a second chance. We're here for rewriting the sentence. Everybody, you have the two judges here. The chief judge spoke a little bit about 3553A and, these sentences that are kind of outrageous. Some people don't belong there. We're here for rewriting the sentence. Do you believe, and we can look at Judge Gleason's decision in Holloway, African Americans are disproportionately destroyed by 924C stacking. I had a case that I did as a jailhouse lawyer for a guy named Billy out of North Carolina, 28 years old, pleads guilty and gets sentenced to a mandatory life sentence. First offense was 8 grams of crack cocaine. Second offense was 3 grams. He was sitting in a crack house, making $500 a week and ends up with life after pleading guilty. I lost the case. Eventually, President Obama would grant him clemency and reduce the sentence to 30 years. Absolutely outrageous. So because we're here talking about rewriting the sentence, like I said, it just destroys African Americans, 924C stacking. I'm white, sentenced to 40 years in federal prison at the age of 24. What goes into your thought process when you're looking at a compassionate release motion? I believe that I've won a couple in front of you pro se for other defendants.
Well, I didn't know that.
So
You know, it's thank you for that question. I had a young man who, it was the first criminal case I tried as a district judge. He was, I think, 20 years old at the time of his sentence. He was in a drug conspiracy. It was, 280 grams of crack cocaine, and he was in it with his mother. Okay, his mother was part, and his mother's boyfriend was part of the conspiracy. He'd had 2 prior state drug convictions. One he'd served 19 days, and the other one he had served like 25 days. Okay, the prosecution filed enhancements on each one of them. So when he was convicted by that, when the jury found him guilty, 280 grams of crack cocaine, I had no choice. I was required to sentence him to mandatory life. Okay, he was 20 years old, and you talk about wearing on my soul, and you talk about being traumatized by that. It bothered me from the day I did it, and it continued to bother me. And it was only compassionate release that allowed me to reduce his sentence. And thank goodness for that, because when I had his 2255, when I had his habeas, I spent like 6 months trying to figure out if one of those predicate state convictions may not have counted, right? That maybe they didn't fall within, and unfortunately they fell within. At the last paragraph of my opinion denying his habeas was, this sentence is lawful but unjust. Okay? It was lawful, illegal, but unjust, and there wasn't a daggone thing I could do about it until compassionate release. And we have a lot of those. It's a ton of work. And let me just say this. We don't get any credit statistically for budget, for staff, for anything from post-conviction things like compassionate release petitions, okay? We don't get extra law clerks. We don't get any money. The clerk's office doesn't get any credit for staffing for it. It's, and so in terms of whether we get funding for more folks to do this, we don't get it. It's just because it's under the old criminal case number. So it's not a new case, right? And so when the folks are allocating scarce resources like dollars, we don't get credit for it. But they're so very important. I'm glad that outlet is out there. So I was able to reduce that young man's sentence from mandatory life to something far, far, far less than that. So I hear you, and I do think that avenue of compassionate release is something that folks like Judge Birotte and I and all the other folks who have our job, it provides us with an opportunity to do justice, okay? An opportunity to do justice.
can I just say this before we go? We definitely appreciate, there's formerly incarcerated people here, judges that do that. We know in the 11th Circuit, U.S. versus Bryant, 7th Circuit, U.S. versus Thacker, there's judges that are like, oh, nope, can't do this. Well, now, thank God Judge Gleason was on that sentencing commission, because I think he was a big force there. I mean, now, as long as things go into effect November 1st, judges can do that. And I want people to know that there's guys in prison that I deal with every day that I was in there with that deserve to get out of prison more than I ever deserved. People like Laval Farmer and Ian Owens. I've been out 3.5 years. There's people in there that can turn their lives around. I'm married. I have 2 little twin boys. I own 2 businesses. People deserve a second chance. And
Thank you. Thank you. Thank you.
So join me in thanking this panel this afternoon. Thank you.
I like to be seen and I like to be heard. Can I have a minute to speak? My name's Sabrathia Drain, and I'm here to represent my brother, Kendall Robinson, with petition, his number is 13074-030. He's incarcerated at FCI McDowell in West Virginia. I'm here because my brother can't be here, and he's not here because he's been sentenced to 30-plus years in prison for possession of 280 grams of cocaine. There was no cocaine found. The only reason he was convicted is because people who had pending charges testified against him. My brother has 2 children. One he's never seen in person, and the only time that that child has seen his face is when they made an illegal call on a cell phone, and I saw my nephew see his father for the first time. His face lit up. He's heard his father's voice, but he's never seen his father. We've submitted over 100, almost 200 letters for commendation for my brother. His status on the BOP is still pending. I don't know if any of you have family members incarcerated. I don't know that. I don't know if you would share that, if any of you do. I don't know how you can measure your success without listening to people like me, right? I have family members. I have had 2 children who were incarcerated. This happens to people like me, right? We have no way to be heard. You know that there's disparities, but there's no way for me to get parity. There's nobody that I can talk to but submit a letter that's always not answered. You're saying
Ma'am,
rewriting.
if you come to me at the break, I promise you, I will take your name, I will take your number, I'll take your relative's information, his petition number, and do my very best to try to get you the help that you want.
Thank you.
Thank you. More on compassionate release tomorrow, by the way. We have a whole panel.